Here. Court does call the case People versus Brandon Kelly.
Al Chavalowski for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Kelly, who's here to my right. Judge, state your name, Mr. Kelly.
Brandon Kelly.
These are the rights that I went over with you, okay? Don't stop. Sign. And then. I'm just having Mr. Kelly sign the advice of rights that I went over with him orally in the lockup. This is just saying that the felony is going to be dismissed and you're pleading to it. Okay? Sign there and date there. Today's the 14th. Also, Judge Valvo will send you to Judge Simpson. Okay? Your Honor, we have executed an advice of rights in a plea form and a sentencing judge waiver.
In the courtroom, tension fills the air as Brandon Kelly stands before the judge. His voice is calm but heavy, pleading no contest to the charge of aggravated assault. The judge carefully explains every right he's giving up, making sure Kelly truly understands. It's a moment where justice feels personal and real.
The plea form indicates that the defendant will be pleading. You didn't check the box. It's a no contest plea.
It'll be a NOLA plea, yes, Judge. The reason being civil liability.
We'll be pleading no contest to the charge of aggravated assault. The 1-year offense, upon the successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Judge. There is no sentencing agreement in this matter.
Right.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Brandon Kelly.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about a no contest plea. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Not this time.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
I have been provided and have reviewed Ann Arbor Police Department report for their case number 2531672. Any objection to the court having reviewed that report?
No.
No from the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, I should say, and you would not be permitted to withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Judge.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 4th at 9 a.m.
November 4th, 2025, 9 a.m. That is before Judge Valvo. Bond will...
If I could be heard on bond, Judge.
Sure.
Your Honor, Mr. Kelly is here on he's a 5,010% bond. He has resolved the felony matter. He has taken responsibility in this matter. His mother has been in court with him every single time, and she's in the front row here. She says that he is welcome to stay with her while he's out for sentencing, and we'd ask the court to grant him a personal recognizance bond, and with any conditions. I think he'd welcome any conditions that would ensure the safety of the public, up to including potential tether and no going to Target. This is an event that happened. Well, you read the police report. You know what happened.
Yeah. Well, I'm concerned about why it entirely happened from his perspective. I guess maybe I'll ask it a more direct way. Are there CMH issues?
Yes, Your Honor. He has there are CMH issues. He has an alternative treatment order. He has received his shot. I believe he's just received it not too long ago. Is that correct?
Yes.
When was the last time you had him?
I can't remember.
But I don't think he'll be due for another shot before he's sentenced. Is my understanding. Don't quote me, but last time he and I spoke, he had just gotten it, and this matter was set for an exam.
Is this right? Is this his only case?
I don't believe there's anything else holding him, Judge. No.
That's what it looks like.
And-
I think it's 5,010%.
Right. And the treatment plan is through probate court, I presume.
Yes, I believe so. If I could just have 1 second, Judge, I have my notes in the.
Well, I guess the other thing I want to know is, was he on the treatment plan prior to this event?
If not prior, Judge, I believe that the two may have coincided.
Well, I get, okay, so here's what I'm trying to figure out. If he's on the plan prior to this event, and then after this event, he then gets onto the plan, that's one thing in my mind. If, however, he's on the plan prior to, maybe not cooperative with that, and then this happens, that's a different issue for me.
Your Honor, he reports that he's just been receiving the shot for the last month.
Okay.
Would have been after the plan. This precedes the shot he.
What I will do is, I'm not going to give a PR, but what I would indicate is that I will reduce his bond to a 1,010% bond. I really would prefer that Judge Valvo, since she has it, take a look at it, given her history with the mental health court. Take a look at it. I'll reduce it to the 1,010% bond. I will also indicate prior to his to be placed on a GPS home confinement tether.
And I will get that address to the court.
But as the hearing continues, something deeper unfolds. The defense reveals Brandon's ongoing mental health treatment, explaining how this case connects to his struggle. The judge listens closely, not just to the words, but to the story behind them, showing that sometimes justice isn't only about punishment, it's about understanding.